Welcome to the 2019 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple. Innovation for your world. LexisNexis, not just more content, but more efficient research tools. Gemini copying and subpoenaing services, assisting both the defense and applicant bar. Arcadia and John Pinto, your structure financial settlement professional. MacroPro copying and subpoenaing services, MedLegal legal services, ExamWorks, provider of workers' compensation evaluations, and MedLink, professional medical legal evaluators, and Amitros savings and support for injured workers and MSA. This year's conference was again held at the historic and elegant Citizens Hotel in downtown Sacramento on March 15, 2019. The Citizens Hotel prepared an exceptional morning brunch and ending the day with fine wines from Ben & Sellers and Frank Family Vineyards. Before we begin, you may wish to download the conference materials, which are available without charge at montalbolaw.com. If you're interested in CEB, MCLE or QME credit, please contact the law offices of Richard L. Montalbo for terms and to receive your certification of completion. The opinions expressed herein are the opinions, legal interpretation, and analysis of the presenters. The viewer of this video presentation is encouraged to review in its entirety the case decision or statute which is being discussed. The Current Issues Workers' Compensation Conference involved 4 separate panels and sessions of just over 1 hour and 30 minutes each and qualifies for 5.25 hours of CEB, MCLE or QME educational credits. The first session will be Case Law Update with the focus on case decision originating with the WCAB. The emphasis for this year's conference is Injury AOE, COE, and will begin with a review of various legal principles and doctrines with an emphasis on a recent decision involving the industrial injury, including the recent California Supreme Court decision of Dynamex Operations West versus Superior Court of LA County. The presenter will be Mr. Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. In addition, Mr. Montalbo is developer and designer of the CompCalc app, the only smart device workers' compensation rating and indemnity app, as well as the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
Can I tell you, one of the funnest things that I do, if that's a word, most enjoyable things that I'm involved in is this conference every year, and this is the 24th year. I want to start out by, first of all, thanking everybody for attending it and the people that are attending out in cyberspace out there. This is what, next year is going to be the 25th year of this conference. And we have one, I know I'm old. What do you do? And I told somebody that I was going to start out by mentioning them because she's not here. She called me up last week and she's only missed one. And we all know her in the industry, Debbie Stopper. And she said she was going to be watching on the internet. And I said, listen, I'm going to embarrass you because you're the one to blame for the coffee service all day. We all know that we have coffee service all day, and part of the reason that we do that is because Debbie came up to me after, I don't know, the 3rd year and said, Rich, come on, man, this is pretty boring stuff. We need something. So yay, Debbie. Let's go through the day's events. For those of you who have not been here, you know, I couldn't put this on, but for I have control over the people that I hire. Sacramento Video's exceptional. They broadcast, take care of all the technology, do all the ads for the sponsors. Of course, the sponsors every year return to help us out with underwriting the cost of this, and then of course my staff. And this year we had a major change. For those of you who aren't aware of this, Maria Navarro. Has been with my office for 17 years, and she's handled this conference during that entire period. She still works for me, but she handed it off to Tori. So this is Tori's first year handling everything. I think she's done well. Let's hope that the wheels don't come off the cart, but it looks okay. So let's go through the day's event. Of course, we have a food service here, and this is why the people in cyberspace should try to get into this conference. This year, and I want to admonish everybody of this, it's really important when you put on a conference like this, I'm giving you some of the logistics, that you register and register early, because you have no idea how many balls are in the air about the food service and trying to put the whole thing together. And for those of you who registered early, I thank you. For those of you that registered late, shame on you, okay? But the food service will be here through the first break. The coffee service will be here throughout the day. They'll be serving double shots only in the afternoon. And then we're gonna, we do a couple of really fun things, and this is why it's fun to come to this conference. You know, I don't know if you guys know this, but I was, in undergrad, I threw a few parties. And this is kind of like an adult party. It's like putting a lot of fun things together for adults. And one of the things that I like most is the wine tasting at the conclusion of the day with hors d'oeuvre pairings. So I want everybody to be aware of that. At 4:30 we'll have a wine tasting. We have some exceptional wines again this year. I like to take credit, but I have somebody that helps me out with selection of those wines. So I think that'll be real enjoyable. Let me talk about the speakers a little bit. You know what I do every year is I go to a lot of conferences as an attendee, but I also lecture at some. And I have an opportunity to listen to everyone out there. And once again, I have invited, and I'm fortunate enough to have everybody that I invited agree to speak. And we have some of the icons speaking here. So let's go through the day's events. For the first hour, I'll be lecturing to you. After that, the second hour, we have Julie Shung and Jake Jacobs-Meyer. And this is what I'd say about both of them. They're icons in the industry. Julius is a partner with Boxer Gershon, and he's somebody that I've watched over the years and listened to, and he's really provided me with a lot of insight, especially from the applicant's perspective. Jake Jacobs-Meyer is somebody that everybody here would say is one of the best defense attorneys in the state, bar none. I would say he's probably the best. He's somebody that whenever I have an issue or whenever I see him, you can ask him this, I always go over and I say, hey, Jake, what do you think? Okay, so, and they're going to be handling injury AOE COE. Then the first lecture, you're on your own for lunch, and then the first lecture in the afternoon is going to be injury AOE COE. I hope I'm getting this, for some reason I'm thinking I'm getting this out of order. But the next panel, one of the panels today, will be injury AOE COE. And on that, we have an absolute icon. You know, it was, and I want to tell a story about on that panel, we have Mike Giacchino and we have Bill Herreras. And 2 years ago, I had an opportunity to speak with Mr. Herreras at State Bar Conference. And the topic was Ogilvy. And we're going through it. And Bill, we kind of transitioned into LaBeouf, which is kind of a companion, depending on the date of injury, and it attacks, you know, the inability to compete in the open labor market versus DFEC. And Mr. Herreras, for about 15 minutes, riffed. That's all I can describe it. It was a riff. He went through the historic background on LaBeouf for 15 minutes. And when he was about to finish, I realized, you know, sometimes when you're really intensely listening, you don't realize your mouth is open. And my mouth was just, wow. And I realized the audience probably realized that I had that wow moment. And so to save myself the embarrassment, I said, I want to be Mr. Herreras. Someday I want to be Mr. Herreras. And so that's what he's bringing. Mike Giacchino is a partner with H&B. He has spoken here on a number of occasions. Mike is, you know, whenever I select people, I want people, number one, that are not true believers. And what I mean by that is they have to be fair and balanced, but we want both sides of the equation. And that's why this conference is attended both in the internet and here by both applicant and defense attorneys. And so that's why each panel I have a defense attorney as well as an applicant attorney, so we can be fair and balanced. The final panel is made up of Jonathan Liff. He'll be joined by Alex Wong And then we have somebody that I've tried for a number of years to come and speak, and that's Dr. Michael Summers. We all use Dr. Summers as an AME. And this is what I would say, first of all, not to do PR for Dr. Summers, but you may not always agree with the AME, but you should always be able to understand their position and what they base that position or that opinion on. And if the doctor's always prepared when you take a deposition, that goes a long ways for me. When I have a doctor that's getting the facts and the dates and the parts and what happened when, I had one 2 weeks ago where we both agreed and this is a long-standing reputable doctor, AME, we're going to go to another doctor because it went that poorly during the deposition. We're not able to settle on that, on his opinion. But every time I've had occasion to get up very early and drive over to, what is it Napa? Sonoma. Because Dr. Summers, if you don't know, one of the things he does is he sets all the depositions at 7:15 or 7:45 or 7:30. I don't know, it's early. He knows that everybody has to drive over there, and he lives there, so he's ready to take on that deposition. He currently is with the Newton, he's become part of the Newton Medical Group. And just to comment on that, Newton Medical is part of ExamWorks. Newton Medical, they report exclusively as AMEs. So Alex Wong is with Jones Clifford in the Bay Area. Alex, I've spoken with him on several occasions, and we've had some contentious discussions in front of people about the law. But Alex is a solid applicant attorney. And then Jonathan Leff is a real decent, hardworking, aggressive defense attorney with Lachlan Falbo in Sacramento. So, okay, let's move on to the next topic, which is the CompCalc. Not a lot of marketing here, but I just want to say a couple of things. This past year, we had a few things happen over the last few years. We had the fee schedule come in for subpoenaing and photocopy services. And that opened up, for me, I felt, an opportunity, which was to make the CompCalc, which I've been working on for 4.5 years, make it available in the iOS version and the Droid version, which is your smart devices, your iPhone, your iPad, and your Droid devices. Make that available free of charge because I licensed it. I modified the look and feel. I licensed it to Gemini Duplication. Now, why Gemini Duplication? Well, it's obvious. They wrote a check. But the other reason is this, that number one, we have a fee schedule. Okay, so photocopying and subpoenaing services all the end. Number two, they have a general policy of not, and this was important for my clients, of not filing liens. Now, it doesn't mean that they don't file liens. It just means they're not going out and filing liens and everything. And I found that, because I'm a defense attorney, that was really a prerequisite before I did anything. One other announcement on the CompCalc, I'm just about concluded, and we're currently testing the AWS version, the Amazon Web Service version. So that means that we would have completed the iOS, the Droid, the Windows 10. So we've got Windows 10, Mac computers, all smart devices, and we don't have an internet version. This past year, Sullivan came out with just an internet version. And so we tackled that, and we're in the testing phase of that right now. So I hope to make that available over the internet to a number of vendors, similar to what we did with Gemini Duplication. So, okay, enough of the PR crap. Let's get to the stuff that everybody's here for. I'm going to do the case law update. The case law update, some of the topics that I'm going to cover are part of the panels. I'm not going to go into a lot of detail on those. Let me go ahead and bring this up. I'm going to touch on AOE COE. I'm going to go into greater detail on apportionment because we don't have anybody covering that. I'm going to touch on a few cases dealing with medical legal procedures, and then I'm going to go through PD. The focus there will be on the Fitzpatrick case. Let's go ahead and let me bring that up real quick here. Now, everybody by now should have been able to download the materials. So you should have those either on your smart device, or I know some people actually printed hard copies. Okay, I'm going to start with injury AOE COE. I'm sorry? I'm not sure what the login procedure. Can we find out what the internet? Citizen Hotel. Conference.
And then,
One word?
well, Citizen Hotel, and then there's an underscore, and then conference.
Okay, so Citizen Hotel _ conference. I should have had this, I apologize.
And then the password is
Password is
Montarbo with a capital M.
Montarbo with a capital M. Montarbo. I should have had that, I apologize. Thank goodness for. Oh, you flatter me. That was a tough decision. We thought about it. There was a small conference on that. We decided to,
He wants Jacob's.
yeah. We could change it to Jake for the afternoon. Okay, I want to start out with injury AOE COE. I'm not going to go into the Dynamex case, but I want to give you a basic outline of how I now approach. You know, last night I lectured at McGeorge to my class, and I said, listen, it's about me tonight. I'm going to go through this lecture with everyone so that they had to suffer through it. But it was a lot of the topics that we've either already discussed or we're about to discuss. Some of it was new, especially on apportionment. What I want to cover is AOE COE. I'm just going to give you an overview. I want to go into apportionment, medical legal procedures, and then PD. Let's start out with AOE COE, and I'm just going to give you the way that I think, given the Dynamex case, the way that this whole area of law operates. I'm a checklist guy. I'm a guy that likes to go A plus B equals C. That's because I write code. That's how my mind works. So let me give you a checklist. This is the way that I look at injury AOE COE. I want broad rules that I can apply to all different aspects of AOE COE, and these are the rules that I have. Number one, that it's incident to a consensual employment relationship, and those are all buzzwords because we have cases involving that. But what does that really mean? Well, under Borrello, we have really a two-pronged test with a factor test. The two-pronged tests are that it has to be benefit conferred, there has to be benefit conferred, and number two, controller right to control. And then we have the restatement second that has a number of factors, really dealing with independent contractor, but also with whether or not they're within the course and scope, and that those factors involve the following: special tools, training, licensing, how are they paid, a number of factors, okay? That's always been the Borrello test. That's what we've always looked at. And let's apply that to a couple of circumstances. You're going to hear a lot more about this during the panel on injury AOE COE, but let's talk about, for example, those tests. So we're looking at the broad test to say, for example, the defense of horseplay. Well, it should be obvious how that applies, right? There's no controller right to control, and there's no benefit conferred with horseplay. For it to be otherwise, the employer would have to do something like, hey guys, this is what I want you to do. Jump on his back, and I get to watch, and I'm going to enjoy it. See my point? Commercial travelers rule. Now, I think that demonstrates kind of the sliding scale of these two tests traditionally. If somebody has a benefit conferred that's greater, the controller right to control might be established at a lesser extent. So commercial travelers is the classic example. There's not a lot of control. You're telling them where to go, what to do. That's the marketing rep or the long-haul truck driver. But the employer is getting significant benefit, so they're within the course and scope of employment. Let's talk about, real quickly, intoxication as a defense. And I'm discussing this for my clients because I don't think my clients fully appreciate the difficulty with establishing intoxication as the defense. Number one, intoxication as defense is a really strong negotiating tool for the defendant. If somebody's intoxicated, you may get a lesser amount, especially with an applicant attorney that doesn't understand what I'm about to tell you. But this is for the adjusters. You have to understand who has the burden of proof and what the burden of proof is with intoxication as a defense. Of course, the defendant has the burden of proof. Why in this? Because it's the defendant that benefits from the affirmative of the issue. Okay? What is the standard, though? Substantially caused. So the intoxication has to be the substantial cause of the injury or death as and when it occurred. Now let me give you a hypothetical. 5 years ago, I put on the hat of an applicant attorney. It was against SCIF, and I did this case pro bono. I took no fee for it. Here were the facts. The applicant had been involved, or the decedent had been involved in a motor vehicle accident. She'd gone to town to pick up some vehicle parts. She was working for CAL FIRE. She was coming back. There was a turn in the road. The road narrowed down. Her tire departed from controlled driving. It flipped over and she was killed. Now, up in Tama County, we have a lot of people that are that use meth. And they went ahead, and this is somebody that had worked in the industry. She had been a secretary for a number of big law firms. She had worked for me for a while. Her husband had come to me and asked me to take the case. I said, sure, and I'll do it pro bono because it looked really clean. It turned out it wasn't, because they had a blood test that was positive for methamphetamines. Now, the issue was, is the methamphetamine, the fact, assuming she was, and there was a huge issue with chain of custody, but of course, what happens in these chain of custody cases is the bureaucrats circle the wagons to say, no, 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 we did it right. We did it right. I don't think they did, okay? But I couldn't establish that. So I had to attack whether or not it was substantially caused by the intoxication was a substantial cause of the death as and when it occurred. I showed up at trial. We had the internist, a toxicologist, who said, yeah, I think it's intoxication is a valid defense. I think that's a substantial cause. But where the defendant screwed up in that case is they didn't link the cause and effect. They needed not only medical evidence, but they also needed an accident reconstructionist. What did they show up with? They showed up with somebody that couldn't link the two. They had an accident reconstructionist that couldn't comment on toxicology. They had a toxicologist that couldn't comment on accident reconstructions. They never brought the two together. Nobody showed the evidence one to the other. So what did I do? The first thing we did was we stipulated to injury AOE COE, because intoxication is an affirmative defense. As soon as we stipulated to injury AOE COE that she was within the course and scope of employment, the judge said, well, Mr. Montalvo, call your first witness. What did I do? Everybody knows what I did. I said, at this juncture, I have no witnesses. There were two attorneys from SCIF. They go, we need to adjourn. They go outside. They come in. They had one witness, this accident reconstructionist. On cross-examination, I got him to admit that anybody driving that car, regardless of intoxication, once that wheel went over the edge and was no longer in controlled driving, it would have flipped and it would have killed him. With that, we won the case. So here's the point. Intoxication as a defense is a difficult defense. The burden of proof is on the defendant. The standard is substantially caused as and when it occurred. Okay? So just be aware of that. Just because, if you're an adjuster here, just because you have a positive toxicology report and they are intoxicated, remember, you have to go ahead and link that to causing the injury, substantially causing the injury as and when it occurred. Okay? That's all I'm going to say about AOE COE. I do want to read one part in the Garcia case. This is on page 3 of your materials. I'm going to read the bottom part of this first box. Editor's analysis. This is what I say. To summarize, it is this editor's opinion that in the end, Dynamex test will become the standard not only for the claim involving wage and hours, but also workers' compensation. There's a lot of controversy on this, and I think it's the Perkins panel decision that says that it doesn't apply. I think in the end, we're going to have the ABC test, and I'm not going to go through that. I'll leave it to the panel. Again, important policy is to prevent the employer from evading wages, tax, and other obligations. Realize that's the policy, that the employer should not be able to parse up and call you an independent contractor and avoid the liability for taxes, wages, and other obligations, i.e. other obligations. That's out of the case. Other obligations, I believe, is workers' compensation. By allowing the court to look beyond labels and evaluate whether the workers are truly engaged in separate businesses as an independent contractor, noting that a business entity should not be allowed to avoid its statutory obligations by carving up its production process into minute steps, then answering that it lacks control over the exact means by which one such step is performed by the responsible worker. So realize that's the policy, and I think that's a good precursor. Let's go on to the gun case. This is on page 4. The reason I put this in here is because it was Jamie Veriker's case, and it involves the following facts. This is on page 4. Tama County Sheriff called up a local private citizen and said, listen, I think Mom and Pa Kettle are having problems over at their family ranch. Can you go over and take a look at it? And so this private citizen goes over. Now, what the dispatcher didn't tell them was that when they got the call to take a look, that the call was in whispered voices, we need help. The private citizen walks in and walks into a murder scene. And the issue is, can the private citizen walking into that murder scene sue the sheriff? Or is that lawsuit, that civil lawsuit, is it barred by the exclusive remedy rule? And in this case, they discussed Labor Code Section 3366, which essentially says that anybody engaging in peace officer, assisting a peace officer at the direction of a peace officer becomes the employee. Now, the purpose behind that was to ensure that people help out peace officers and that they're covered for workers' comp. But in this case, when you want to sue the peace officer, you probably don't want the exclusive remedy. But what they held here was the exclusive remedy was a bar to that lawsuit. Okay, that concludes. I didn't know that. Mr. Herrera says that the Supreme Court just granted review on this, so I guess that's not the final word. Okay, let's go through apportionment. I'm going to give you a checklist for apportionment, some of the doctrines that we need to understand for apportionment in a nutshell. And this is good for all the attorneys, all the doctors that are watching this or attending this, because it's a great overview. And we don't have a panel on apportionment, but a lot of things have happened this year. This is the way that I look at apportionment. We have 3 doctrines that we have to understand. We have the doctrine of direct causation, we have the doctrine of substantial evidence, and we have the doctrine of burden of proof. Let's start out with, in reverse chronologic order, burden of proof. This is what I want everybody to take away on burden of proof, because it's a concept that, we hear it all the time. What does it actually mean? What is burden of proof? You have to know 2 things. This is what I tell my students, 2 things about the burden of proof. Number 1, who has it and what's the standard? Okay? The standard generally in a workers' compensation matter is a predominance or preponderance of the evidence, greater than 50%, okay, more likely than not. Okay, that's the standard. Who has the burden of proof? It's a simple rule. Listen to this, because you're going to hear a lot of explanations on this, but this is just a simple rule. The party that benefits from the affirmative of the issue has the burden of proof. Now, the burden of proof may shift back and forth, but the party who benefits at that point in time of the affirmative on the issue has the burden of proof. Okay, so that's the burden of proof. Who do you think has the burden of proof with respect to apportionment? Who benefits from the affirmative of the issue of establishing apportionment? It's the defendant. That's the old Pullman-Kellogg case, right? So it's the defendant, and that hasn't changed. It's the defendant that has to come forward to establish that there's a non-industrial or successive industrial causative factor that is responsible for the permanent disability that presently exists. Number 2, direct causation. Now, this is a doctrine that comes out of a number of cases, and this is the way that I explain direct causation. The employer is only responsible for that portion of the permanent disability that is directly causally, and this is my word, exclusively related to or caused by the subject industrial injury. Directly, causally, and exclusively. So that portion of the permanent disability that is attributable to some other cause, the employer will not be responsible for. Now, you lay all that over another doctrine, substantial evidence. Substantial evidence, simply put, requires that whoever provides the opinion provide the how and why, the A and IRAC, the considered and reasoned analysis. They have to explain their opinion and what it's based on. In workers' compensation, there's going to be a factual and a medical basis. They're going to use those facts and that medicine to support their conclusion. If they fail to do that, if they're conclusory on their opinion, then it will not constitute substantial evidence. Okay? So those are all the doctrines as we move through this. Substantial evidence, as described by Escobedo, for causation of disability pursuant to Labor Code Section 4663, has the following elements. This is the way, every time I read a report on apportionment, this is my checklist. Number 1, It has to be a full, complete, accurate, this is the medical opinion. It has to be a full, complete, accurate medical history with a proper diagnosis. Because if it's not full, complete, if it's not accurate, if it's not a proper diagnosis, then guess what? That apportionment is not going to constitute substantial evidence. Number two, it has to be explained within reasonable medical probability based on the doctor's education, training, and experience in understanding the facts involved in the case or presented to him by way of a hypothetical. Okay? So what that means is it has to be within the field of the doctor who's providing the opinion on apportionment. You can't have an orthopedist discussing psychiatric conditions. You can't have a psychiatrist discussing internal medicine. Okay? And number three, and this is where most of the litigation involves, the substantial evidence requirement, that they have to explain the how and why. They have to connect the dots. They have to do the A in IRAC. It has to be considered in reasoned analysis. What they're doing there is the doctor is really writing a law school exam. They have to tell us what facts, by way of factual evidence or medical evidence, supports their conclusion that there is apportionment to non-industrial causation. Okay? So all this entire test goes to non-industrial causation. Okay? The presence of non-industrial causation. I would suggest that with respect to the percentage, and we have a number of panel decisions, early on, the applicant attorneys were attacking the apportionment, saying, well, doctor, you say it's 15%, why isn't it 16%? Why isn't it 14%? Well, then you're speculating. We had a number of panel decisions that said, no, that's not the way it works. As long as that opinion, in terms of percentage, is within reasonable medical probability and you satisfy the Escobedo standard, that's going to constitute substantial evidence. So what I say, the presence of non-industrial or apportionable causation, that requires the Escobedo standard that we just went through. But once the doctor reaches a percentage, that will be upheld unless it's arbitrary, capricious, or without rational basis. In other words, the only way that that's going to be overturned is where the doctor's completely off the reservation. You know, there's no pathology, there's no symptomology, there's no treatment, and he finds it 50% apportioned to who knows what. Now, whenever I discuss this with doctors, to meet the substantial evidence test, they need a roadmap. And this is what I tell the doctors. Look at PST and the word severity. P is pathology. How severe is it? The presence and severity. Symptomology, presence, severity. And treatment, presence and severity. Also, severity of injury. Now, think about that. If a doctor addresses all of that, his opinion is likely to constitute substantial evidence on the issue of whether or not there's a valid basis for apportionment. Okay, let's talk about any questions? Okay, let's go ahead and talk about Hunosa. This is a substantial evidence direct causation case. And the applicant attorneys have suggested that, and I'm going to take issue with this, you know, I'm an equal opportunity because I have a unique opportunity to throw bombs at both sides, right? Because I have a small practice, I don't have a bunch of partners that I have to answer to, so I can call balls and strikes. And I'm going to on Hunosa and some of the other cases. You're not going to like what I have to say about if you're a defense person on the lung case and the Rice decision before that, the risk factors. But I have a pretty good analysis on that. But Hunosa involved the following. In 1970, back surgery. The date of injury was not until it was it was 11, so that's 40 years later, the applicant has an industrial back surgery, injury that results in back surgery. And the issue was there were no medical records regarding the 1970 injury, okay? And the doctor tried to apportion to that. Now, the issue, what the applicant attorneys would suggest to us, some of them, is that without medical records, you can't meet or satisfy the requirements of substantial evidence. That's why apportionment doesn't apply in this case. But I don't think that's the case. I think, and my analysis is identical to Steinkamp. Steinkamp was a case that came down, and I spoke at CAW, and there was a real aggressive discussion over the fact that I said Steinkamp doesn't mean, let me give you the facts in Steinkamp, bilateral knee or total knee replacement surgery, the argument was that once you remove the pathology, you have nothing to apportion to, and therefore you're not entitled to valid legal apportionment. I said, no. It's a how and why case. What the doctor should have said was, the pre-existing pathology became symptomatic. It's that symptom and pathology that was pre-existing and non-industrial, combined with the industrial injury that led to the need for the surgery. It's that surgery that we're rating. So now I'm going to look at the pathology, the different ingredients, to apportion those out, okay? I look at this case the same way. The doctor failed to satisfy the substantial evidence test. What he could have done in the absence of records is the following. There was an x-ray close in time to the industrial injury. Why didn't he focus on the pathology that was present on the x-rays and the diagnostic studies, which he didn't, close to the date of injury, and say, within reasonable medical probability, we have a specific acute injury here. I don't believe that that level of pathology could have been caused exclusively by the subject industrial injury. I don't have the medical records. I don't know what the prior surgery was, which was a point of contention, but I do have diagnostic studies close in time, and I do know within reasonable medical probability that this degree of pathology wouldn't be associated with this acute injury. And that, if he'd done that, I think it would have been. So I don't read this case as saying if you don't have medical evidence, medical records, going back to an earlier date of injury, that you're not allowed to do apportionment. I would agree that it makes it more difficult, because if you have the records, if you have the pathology, if you know what the treatment was, if you know what the surgery was, then you're probably going to be able to support that, the finding of apportionment to non-industrial causation much easier. But that's the Honosa case. Okay, here's the hot topic. Hot topic. Let's talk first about the City of Jackson versus WCAB Rice decision. I've said this for years, and it has to do with risk factors. Let's go through the facts on them, and we'll discuss. Yeah, we'll discuss risk factors real quick. The facts in, it's not in your materials, but the facts in the Rice decision are as follows. The applicant was a police officer. He had severe degenerative changes in his back. He was relatively young and a relatively short period of employment. And the issue was, how do we find apportionment? Well, there was a genetic predisposition. His family actually had a history of this condition. And what the defendant wanted was, they wanted apportionment to genetic predisposition. The doctor first said no, then subsequently did some studies and saw that there was some research, some support for that, and apportioned directly to, and the only way to read it is there was direct apportionment to risk factors, here the genetic predisposition. There is one line in there, and if you look at my summary from last year, there's one line that I say the court should have started and stopped with that line, and that line went something to the effect that there's no prohibition to apportionment to pre-existing pathology were caused by a genetic predisposition. That line, I think, is fairly accurate, because you're apportioning to the blankety-blank pathology. Okay, now I want everybody to understand this. I think the law right now could be argued that you can apportion to risk factors. But a doctor that does that, number one, listen to this, ladies and gentlemen, number one, will generally not be used as an AME, okay? He will not be used as an AME. Number two, apportioning to risk factors. I'm not saying by saying you should not apportion to risk factors. I think it's a difficult task to do and satisfy the substantial evidence requirement. But risk factors are relevant. Here's how they're relevant. The doctor has the obligation to establish that the pathology, and remember direct causation, that pathology has to directly impact on the disability. It has to cause that disability, okay? The doctor has to establish that that pathology is pre-existing and or non-industrial. Now, one of the reasons that he could find that it's pre-existing and non-industrial is what? A genetic predisposition. So that genetic predisposition, or whatever risk factor, can be used to demonstrate that that pathology that he's apportioning to is pre-existing and non-industrial. That's the relevance of risk factors. I think a doctor that wants to bypass everything and only apportion to risk factors, that's a tough road to hoe. Okay? So, but I'm not saying, what I'm not saying is that risk factors are not important. We ask those questions at the deposition all the time. Why? Because it's those risk factors that the doctor uses to support their conclusion that the pathology that they're apportioning to is pre-existing and therefore non-industrial. That's a pretty fair and even balanced analysis on this, I think. I'm looking at Mr. Jacobs-Meyer and Mr. Herrera and seeing if they will even nod their head in acknowledgement. Anyway, that's what I tell my, my clients could be a problem. That's how I like to analyze it. A doctor that wants to bypass all that analysis and go directly to, I'm just apportioning risk factors because his mom and dad had this problem. I think that that's wrong. What you do is you say, mom and dad had this problem, and that justifies my conclusion in part that this pathology is pre-existing and therefore non-industrial. And then go through the apportion to it. Let's talk about the lung case. Here's what happened. He was a police officer. He took 3 to 6 blows to the head. Now, this is a case that really, I think it blurs the line of causation of injury and causation of disability, and it's really a direct causation case. Let me go through causation of disability and causation of injury and causation of disability. This is the way that I teach this. It's a lot easier for people to understand the difference if they think about it in chronologic order, because they sound, causation is the first word in both. Are you talking about causation of injury or causation of disability? It's chronologic. You're talking about causation of injury at the inception. Do we have an industrial injury? And there the standard is de minimis. We've got South Coast Framing, we've got the Porcini case that say that if there's a mere contribution, something greater than zero, that by way of an industrial event, activity, or exposure, that leads to producing that disability, guess what? You have an industrial injury. That's why CTs are so difficult where somebody's worked for an extended period of time to defend AOE-COE, because you just need a mere contribution. Now, what's the legal ramifications of establishing injury AOE-COE? Well, guess what? The employers, the defendant's on the risk for what? 100% of those unapportionable benefits. That's going to be what? It's going to be temporary disability. It's going to be medical treatment. We don't have a case on it, but supplemental job displacement benefits. You only get the apportionment under the second aspect, the second doctrine, causation of disability, 4663 apportionment. Okay? There, I've already gone through the analysis on that. You go through those steps, and but that's the separation. So what happened? He got in the lung case. He 3 to 6 blows to his head. Subsequently suffered headaches, and 9 months later lost most of his vision in his left eye. The diagnosis was left ischemic optic neuropathy. Now that's an abnormal blood flow. That's what that condition does. Due to the abnormal blood flow, he developed ultimately loss of vision. The issue was, is it the result of this canine hitting him in the head 6 to 8 times or whatever it was, or is it related to this non-industrial pre-existing condition, this abnormal blood flow that led to the, and I want to read this to you, and I want everybody to tell me what the relevance of this is, because it was put in the opinion, and I have my thoughts on this. Okay, Dr. K also concluded, as had other physicians, that Lung's blood circulation in his left eye was defective. Okay, that's relevant. He stated Lung did not have any disability prior to receiving the blows to his head. Okay, well, that could be coincidence. And absent the injury, he thought Lung most likely would have retained a lot of vision in his eye, although he could not guess how much. Dr. K agreed it was possible that Lung could have gone his entire life without loss of vision. Now, I'm going to be frank with you. Whenever we're analyzing causation of injury or causation of disability, realize this. It's okay now to be a Monday morning quarterback. What might have, should have, could have happened in the future is of no consequence, because we're in the present now, and the doctor's able to look in the rearview mirror, hindsight, and go ahead and parse out those different industrial and non-industrial causative factors, and that's really what they do, okay? So when the attorney takes a deposition and says to the doctor, how can you say that he would have had this level of vision had he not had the blows? And the doctor says, well, I can't. That's not hitting a home run. It's of no consequence, because you're asking the doctor to speculate into the future, which is of no consequence. The doctor now is in the here and now. He looks at all the different causative factors, and he apportions to those as he understands that they exist currently. So I think that's of no consequence. And they devoted a couple of paragraphs in there. Ultimately, the Court of Appeals reversed, holding that apportionment under 4663 to an asymptomatic pre-existing condition must be based on substantial medical evidence that the condition was contributing cause to the actual disability. That's direct causation. It has to contribute. You don't apportion to pathology that doesn't, in part, cause the disability. Okay? So you have to have direct causation. Further, a pre-existing non-industrial condition may be the basis for apportionment even where the condition had caused no disability prior to the work-related injury and might not have become symptomatic disabling without the work-related injury. Last apportionment to risk factors associated with pre-existing conditions proper, provided the apportionment is not based solely, that's important, solely on risk factors, but on the actual direct causation the actual cause of the disability. So I think that so let me tell you, I don't, and I cite, we have a number of cases involving risk factors now on both sides, and they all turn on substantial evidence, and I think the courts are missing the point. They are, in every case, they're not apportioning to risk factors. In the end, they're apportioning to pathology. And they're using the risk factors to support that the pathology was pre-existing and therefore non-industrial. If you're a physician here and you say, hey, guess what, I can shortcut this and just say, listen, I see a genetic predisposition, I'm going to apportion 20%. I would challenge that, and I'm a defense attorney. I would be very, very concerned about that sort of an opinion. Any comments? As I look to the... Let me tell you, we have some icons in the audience, and if you think that that is not a little overwhelming, you're just, and I haven't mentioned Peter Slater, as he and I have practiced law for 30 years together, man, and I saw him at the board the other day, and he said, hey, I'm coming to your conference, and I go, wow, thanks. That's a nice thing to do. So, okay, any comments? Anybody want to say, Rich, you're not making any sense? This is your one opportunity. Okay. You know what I want to do? I want to, because I'm running out of time. Let's go to Stockwell Harris. This is an interesting case, and it involves a disability or a member of our workers' comp community. What happened was this defense attorney had Parkinson's disease. And this demonstrates the concept of injury through aggravation. What happened was he argued that the stress associated with the Parkinson had aggravated his condition. And he argued that there was no valid basis for apportionment under 4662B. Okay? And we're going to get to Fitzpatrick. I'm absolutely going to discuss that case today because I think it's important. But they said that he argued that there was no apportionment. Here's what I would say. Certainly you can have an industrial injury by way of aggravation where there's permanency. And that's the critical, as I see, the critical difference between aggravation and exacerbation. It's permanency of the condition. Where you have an accelerating condition, it's progressing over time like Parkinson. If that progression is accelerated through aggravation so that you have a permanent change in the baseline over time, then I think you have an industrial injury. So there was no question in my mind, because the medicine supported it, that there was an industrial injury by way of aggravation. A closer call for me is whether or not you can apportion where you have 100% under 466. Actually, it was, in this case, it was 4662A4, mental incapacity. And I think it's a closer call there on whether or not you're entitled to apportionment. But be aware, this case says you're not entitled to apportionment, and I think that's the import of that. I'm going to pass the Camacho case, but let me share one hypothetical with you. I was chastised about 6 months ago by an attorney and a judge. The judge ended up, to her credit, apologizing in open court to a group of attorneys. So I take my hat off to her. Here's what I was chastised for. It was an applicant that was allegedly, supposedly double dipping, had successive injuries. We didn't know about the other one, and they were submitting mileage reimbursement requests to both and keeping the money. When she found out, she sent us a check for just under $5,000. Okay? I go to the deposition. They assert the fifth. I go to the deposition, and I take the applicant attorney outside. I said, man, you know, I just want to close my file. Why don't we do this? And I made an offer on this case of, I think, $80,000. we're going to pay 60 because we had huge reserves up on this. There were a lot of problems with the case. It justified 80,000. I offered 80,000. Skiff was going to pay 20. Skiff attorney was there, 60, but I wanted a voluntary resignation. Now, I want to see, by way of a show of hands, how many people believe that making an offer by way of compromise and release to include a voluntary resignation, we all know why we have to have that, right? Because they're going to go back and file another one. We just paid for the medical. How many people believe that that's inappropriate, unethical, or otherwise? Anybody? Raise your hand. Don't be shy. Okay, of course, to make that offer, you think that's inappropriate, unethical? What? Hold it. Let's listen to this. There you go. And that's what the Camacho case suggests, that you can settle other aspects outside of the CNR between the parties. It is not unethical. It's not inappropriate, because I can't be forced to CNR. So if you want me to CNR, I can dangle the carrot out there, and we do it all the time. That's the only point I want to make, that it's acceptable in the industry. I don't think there's anything inappropriate. Yeah. Okay, you cannot bring, this is absolutely correct. You can't raise criminal liability as a basis. And that's, in that case, I did not do it. I was too smart for that. I just said, kind of hemmed and hollered and said, well, you know, it looks a little questionable, yeah, right? That's what you do. Okay. Yeah.
Just a little update. You're on the Sika case and the Stash case?
Yeah.
Court of Appeals granted return.
Okay, so there's another one, a panel decision that's up to the Court of Appeal.
It's on it's under Sika, it's right below Link, right below the stoplight rescue.
In the box, I'm sorry, where was that, Jake?
It's right under this, it's the heading under the stoplight rescue. It just says Sika. I'll look and see if I can.
Who wrote these materials? Can I tell you, I was telling Jake that I probably have 800 hours of study in a year to prepare for this and do my book. So, anyway, I'm not seeing it, but it's in there.
It's at the bottom of page 12. It just says Sika. It's a case called the Stash versus Stash Check. It's an issue of special general employment with Sika. And that's actually a case involving travelers, so it's called the Travelers versus WCAB, the Stash.
Okay,
This has 200 of those cases, and
okay,
ANG has 30 or 40.
Wow.
30.
okay. Okay, I just want to touch on King. Here's what happened in King. It was another attack that really would have undermined the UR process. And as a defense attorney, I see the benefits of UR, I also see the problems with UR. For example, last week, we had an RFA in my office that was submitted and approved for a shoulder surgery and post-surgical PT, okay? The doctor then submitted an RFA for pre-op care. The pre-op care was denied. Now, what do you think I did? I called up opposition counsel and I said, listen, I have you. No, I didn't. I called up the adjuster and I said, listen, this is crazy. Override the UR, and that's what we did. But what happened in King is the applicant was taking Conopin, and they submitted a RFA for additional Conopin, and the UR denied it. And if you cut somebody off of Conopin, their withdrawals can be just absolutely catastrophic. So the applicant sued who? The UR doctor. And the issue was, can you sue the UR doctor for failure to warn? Okay? We know in a negligence, malpractice, duty breach causation standard, the issue was duty. Do they have a duty to warn, and is that actionable? What the court said, well, hold it. You might have further injury, but that's within the exclusive remedy rule, falls within workers' compensation, and we're not going to allow you to sue the UR doctor. When that went up, that by itself would have undermined, I think, the UR process significantly, but they held that it was not. Okay, I'm just going to jump ahead because I'm not going to, what I want to do is I want to discuss Fitzpatrick. This is one of the, I'd say Dynamax and Fitzpatrick are two of the most important cases. Last night I had the pleasure of having a drink with Mr. Herrera, and he and I were discussing this. And last year, the California Applicants Attorneys invited me to speak at their spring conference on permanent disability. And Fitzpatrick had not come down. We didn't know what it was. And during that lecture, I had Art Johnson on the panel. He remembered. And here's like 800 attorneys. And I'm going through what I'm about to go through. And Art leaned forward. He goes, "You're wrong." And I didn't know. I looked over excuse, what? He goes, "You're wrong." And I said, and I'm a polite guy. I don't like, I'll fight, but somebody has to really start it, right? Anyway, and what I said was, well, let's assume I'm wrong. Probably the defense attorneys are going to think about this the way I do. Let's just go ahead and listen to what I have to say. And this is what I said. 4660 and post 1113, 4660.1, prescribe you have to go through those sections to establish PD, and you establish it one of four ways. Now listen to this. Number one, the standard rating and the standard method chapter or table. Here, objective findings are critical. It's the objective findings that lead the doctor to the proper diagnosis. It's that diagnosis that leads the doctor to the proper table, chapter, or method. Okay? Subjectives are important under the standard rating for two reasons. Number one, they validate the diagnosis. Okay? And number two, oh, look at that. Thank you. Am I winding down? They validate the diagnosis, and where appropriate, provided the doctor explains it, but it's generally not enough money to litigate, so we don't have a lot of cases, he can add up to 3% add-on. Combined value equation is standard for the standard rating, standard method chapter table. It's generally used. Now you might say, what about Kite? And I'll show you where I think that fits in. Second method, Guzman. Guzman has three elements. Number one, the doctor has to start by providing us with the standard rating and the standard method chapter table, focusing on what? Objective findings. Then he has to, number two, tell us why that standard rating, standard method chapter table is not accurate, focusing on what? ADLs, activities of daily living. Then number three, if it's less than complete, incomplete, not accurate, inaccurate, and he explains why, substantial evidence, he's free to go to an alternate method chapter or table within the 5th edition of the AMA guides. Now, where I put Kite is the aggregation often based on the principle of synergy. That's where 2 + 2 = 5. Where I put Kite is as an offshoot of Guzman, because they're really talking about accuracy. And we have a case now that came down that said that really is a medical determination, whether or not aggregation, just adding them together, or the combined value equation that results in a reduction should be applied. Okay, so that's where I put that. The third method is the Ogilvie Guzman. And I just want to talk about Ogilvie, and I'm going to demonstrate this by way of a show of hands. How many defense or applicant attorneys or adjusters currently have an ongoing, hotly litigated, hotly contested Ogilvie case? Okay, 1, 2, 3, probably a half dozen. Okay? Why is that? If I'd asked that 4 years ago, half the audience would have raised their hand. Why is that? It's for the following reasons. The doctrines we've already gone through. Substantial evidence, burden of proof, and now we have the Dahl decision that says, hey, guess what? Amenability to VR services. Substantial evidence, first burden of proof. Who has the burden of proof on establishing, attacking the DFEC, that's what you're doing with Ogilvie, through VR evidence? Who has the burden of proof? It's the applicant attorney. How does the applicant attorney meet that burden of proof? We don't have VR anymore. Through what? Just VR testing? It's a difficult road to hoe, is my point. And they have to demonstrate that they're not amenable to VR services. Now, there's a lot of argument about what that means, but I'm a simple-minded cowboy up in the north. This is what I say it means. That amenability to VR services means nothing more. Can they benefit from VR services? So in my mind, I say amenability to VR services is just exactly like medical treatment under Guzman or the standard rating method chapter. Until they complete the medical treatment, you don't know that they're permanent stationary and what that level of whole person impairment is. Until they complete VR a determination that they are not amenable to VR services, you don't know what their DFEC is, or under LaBeouf, the inability to compete in the open labor market. I think LaBeouf is a little easier to establish because you're not attacking a DFE schedule that's presumed. You're just bypassing that through medical evidence, and this is the one area where work restrictions are still important. And this is what I tell the doctors: don't comment on VR issues. You provide us with the work restrictions. It's the VR expert that takes those work restrictions and tells us why the DFEC is scheduled, has been rebutted, or under LaBeouf, the diminished future earning capacity or inability to compete in the open labor market justifies a higher level of disability. One comment on that, and that has to do with the fact that Fitzpatrick has this statement in it that, just kind of a cavalier statement, that LaBeouf, and they go to LaBeouf, and the date of injury suggests, anyway, it doesn't matter, suggests that it should have been an Ogilvy analysis, but they say that LaBeouf only applies to 100% cases. How many people here believe that LaBeouf, well, let me ask you this, was LaBeouf a 100% case? No. It was it stands for this proposition. See, I'm an equal opportunity slammer here. Now the defense people are saying, what the hell are you saying this, Rich? LaBeouf was nothing more than using VR evidence, based on medical evidence, to increase the level of PD. Not establish solely 100%, but just to increase the level of PD. So I don't believe for a moment that LaBeouf is limited to 100% cases. Okay, let's talk really quick about Fitzpatrick. I think I went through everything here. Here's what happened in Fitzpatrick, and we all know because this came out of Sacramento, we know everybody. It was Judge Temkin. Judge Temkin is a smart son of a gun. He's a very intelligent judge, okay? But he believed, and let me give you the facts. The applicant had a cardiologist report that rated out at 97%. The psychiatric report rated out at 71%. Now, if you do aggregation, that's what, 163? 168, I guess. Okay, so you're thinking, wow, this sure as hell smells like a 100% case. But when you apply the combined value equation, it works out to 99 because there's mathematically, I don't care what numbers you're adding, you can never get to 100% where the combined value is agreed should be utilized. Okay? So what do? Now, what the judge did was he said, hey, listen, man, 4662B says according to the fact. I can look at all the evidence and say this person's 100%, which is what he did. Now, I don't think that's proper, and I know that's what the applicant attorneys have always wanted, have a judge decide according to the fact that they're 100% disabled. What Fitzpatrick says is what I said or suggested to the applicant attorneys last year, which is this. You have to go through 4660 for this date of injury, 4660.1 for post-1113 date of injuries to establish the method by which disability should be awarded. And it's going to be one of those methods. That's all it stands for. Okay, listen, I cite all the kite cases in the box in Fitzpatrick. You know, if I were you, I would go through and read these little summaries of little summaries of big cases. Here's why. You're going to see overriding the principle of synergy involved in most of these. This is where somebody has multiple parts of body, multiple disabilities, multiple conditions that are rateable. And here's my theory on how kite should be applied. This is a conservative theory, but I think it makes a lot of sense. Because the combined value equation is intended to what? Reduce the likelihood of overlap. Okay, supposedly. That's the intent behind it. I think that aggregation should be utilized where you have separate parts of body, not the same region. Where you have the same region, I think it's more likely that combined value equation is going to apply. Now think about this logically. Somebody has an injury to the back, cervical, thoracic, and lumbar. That's probably a combined value equation because there's going to be some measure of overlap there. Okay, generally. There may be arguments otherwise. But where somebody has a left leg and a right arm and a neck with the same overall 10-10-10, you're probably going to argue that the combined value equation shouldn't apply there because you're dealing with multiple parts of body, and somebody who has the same level of disability but involving multiple parts of body probably shouldn't have that disability reduced, but should have the full value of that disability. And we have a panel decisions in your materials that suggest that that's a medical determination by the doctor on whether or not the combined value or the aggregation should be applied to that. I'm not going to go through the Jamaro case, but I want to go through the Caseta case. And this is a further adoption. Well, let me say two things about this case. Whenever a doctor is digging a hole, I don't argue with him. By God, I give him another shovel. Okay? Because when I go to a deposition, I had one this past week with a doctor, a good doctor. I didn't agree with what he was saying. He didn't give me smack. Okay? It was a hard presumptive case. And anybody who does defense work knows you don't win the damn things. Okay? You take some swings. You hope to get a better deal than otherwise would be the case. But during this deposition, I was frustrated because I actually spoke to another doctor, and I thought I had a pretty good strategy, and he blew it all out, okay? I was focusing on overlap, and the doctor sidestepped me by saying, I considered it. Did you see this one sentence here? And it didn't really say what he said it said, but I could see how it could be interpreted what he said. And so he said, in the ranges that he applied, he considered overlap. So that was a big part of my argument, and then there was hypertension, whether or not the presumption applies. And anyway, but a good doctor. I never once lost my cool. I just kept asking questions. And at the end, I thanked him and licked my wounds and walked out of the office. But if a doctor is a little bit bullheaded, just demonstrate on the record how foolish and how inaccurate and how wrong he is. Let him go off that cliff. Don't give him a parachute, okay? That's what happened in this case. Let me give you some background, first of all. It has to do with whether or not subjective complaints are rateable, okay? How many people here believe that subjective complaints are generally rateable? Okay, generally they're not, but there are exceptions. There are exceptions. And it started with the Payne-Moritz case. That was a panel decision involving, it came down, I don't know, 5-6 years ago. And that's the first inkling that caused me to go, holy crap, it's in my book. But it was fibromyalgia, myofascial pain syndrome. And they rated it. And the problem with that is it was purely subjective. That case was followed by the Cannon case. Remember the Cannon case? It came out of the city of Sacramento. And I think plantar fasciitis. Yeah. And it was a policeman, and it was handled by Mastagni's office. In fact, the judge in Oakland actually argued the case. Who's the judge in Oakland? Ledger, Eric Ledger, good judge. He argued the case. It was his win. Here's what happened in that case. And I don't agree with everything. There's one line that scares the heck out of me as a defense attorney. But here's what happened. Is the diagnosis was plantar fasciitis. As a defense attorney, I think there's some critical facts in that case. Number one, they used an AME. Number two, the PTP agreed with the diagnosis. Number three, you had a credible applicant. There was no issue of credibility. The guy had plantar fasciitis. The issue is, and then number four, there is no rating in the AMA guides for plantar fasciitis. So the issue is, first the doctor, it was Dr. Ramsey, good orthopedist, he says, hey, it's 0. They write back and they say, well, hold it, doc. We want you to take a look at Guzman. He comes back and he does something really reasonable. He gives us 7% that adjusts to 9 or 12 or something. It's nothing. Now, as a defense attorney, I would not fight that. You know what I'd do? I'd stip it, tell my client that we have 4664, apportionment to a prior award, because this guy's still working, and when he files his final claim, we're going to be able to get apportionment, and you're going to save all the money by way of further medical and me, okay? That's the way I would have handled it, but they didn't do it. They took it all the way up. And what the court ultimately held was that in those limited circumstances, and I think those facts are critical. Remember what I said. AME, PTP, agree on the diagnosis, credibility, no rating in the AMA guides. They said that rating subjectives was appropriate. Now we jump ahead to this, and this is the doctor that, and I don't know this doctor, so I want to be careful. Hopefully he's not watching. But I want to tell you what happened here. The date of injury, it's a CT through 9/10/14, cervical spine, shoulder, arms, and wrists. The QME found no rateable disability whatsoever. for the cervical spine and the bilateral wrist, but only 4% for the shoulders. APA, the app attorney, notices the deposition. And I want to read this to you. This is what you do is you just stay out of the physician's way. All the doctor had to do, well, I'll tell you what he had to do, what he should have done to reach the same conclusion, and he wouldn't have gotten in trouble. But this is what he said. This is him. You can tell he's kind of wound up because it's kind of broken English. This is right out of the opinion. So that basically what zero rating and impairment means, it's like I really can give you a disability based on the fact that your symptoms are subjective in nature, and I find no objective evidence to substantiate your complaints. Meaning, if you tell me you have this and this and this and this wrong with you, or you tell me you have nothing wrong with you, I will evaluate and I will find the exact same. That is where, in the end, I came up with no rateable disability. Then he says, listen to this. In my opinion, this patient has all subjective complaints. She's not eligible for any impairment and rating in any way, and I don't want to measure impairment. Essentially, in the end, I'm not going to address Guzman. What the doctor should have said was this. Listen, I'm addressing Guzman. I don't find the subjectives to be verifiable, reproducible, evidence-based. I don't believe those are supported by objective findings. I've considered the subjectives, and I don't find them under the Guzman analysis to be consistent with justifying a rating. I don't believe Guzman applies. That's what he should have said. He should have gone through the analysis to do away with a Guzman argument. Instead, he said, I'm not even going to consider it, I'm done. What they said in this case was, that's the wrong way for the doctor to handle it. The doctor should have addressed Guzman, he should have analyzed it, he should have said why the subjectives, in his opinion, should not be were not rateable. And instead, he just bypassed it. Now, think about that. That goes both ways, doesn't it? A doctor should address Guzman, always, sometimes finding that it's accurate, that the standard rating, standard method chapter table is accurate, sometimes finding that it's not accurate. But the point is, he should always, as a general rule, address it, especially where asked to. Now, all the cases are breaking down, and I'm just going to leave you with this because we're almost done with my session. All the cases are falling out this way, okay? Listen to this. Objectives with additional objectives, not within the standard rating method chapter or table. That's the classic Guzman. Okay? Objectives with additional objectives. Objectives with additional subjectives. It depends on whether or not those subjectives are verifiable, reproducible, evidence-based, whether or not there's support for those subjectives, and rating those. Where you have the difficult cases where you have subjectives with additional subjectives, do you rate those? And I would leave this thought to you. I think that Canon gives us a limiting factor for application of for physicians to rate subjectives, which is this. If there is an agreement on the diagnosis, and it's a valid diagnosis, and the applicant has no credibility issues, there's no, embellishing, and where arguably there is no rating within the 5th edition of the AMA guides, I think those subjectives are going to be rateable. And I think that's that's what I would argue as a defense attorney. Okay, to get all your units, I'll expect everybody to read the next, for 2.5 hours, the rest of the stuff that I wrote, because it's really, really important. Okay, that's it. And we're going to take a break. We'll come back in 15 minutes with the next session.